Good afternoon. The Public Safety Committee will now come to order. Madam Clerk, will you please call the roll?
Alderman Oldenburg.
Here.
Alderwoman Clark Hubbard.
Here.
Alderwoman Keys.
Present.
Alderwoman Velasquez.
Present.
Alderwoman Sanye. Alderman Aldrich. Chair Narayan.
Here.
Alderwoman Sanye. We have 6 present. We have quorum.
Thank you. Quorum being present, I will entertain a motion to approve the minutes of the October 3rd, 2024 meetings.
So moved. Second.
All right, it's been moved by Alderman Aldridge, second by Alderwoman Keys, that we approve the minutes of Thursday, October 3rd. Madam Clerk, will you please call the roll?
Alderman Oldenburg.
Aye.
Alderwoman Clark Hubbard.
Aye.
Alderwoman Keys.
Aye.
Alderwoman Velasquez.
Aye.
Alderwoman Sanye. Alderman Aldrich.
Aye.
Chair Narayan.
Aye.
Alderwoman Sanye. We have 6 aye votes.
All right, with that, we've sustained the motion and we have approved the minutes. We're going to take things slightly out of order today. I'm first going to, I'll be handling Board Bill number 111 at the request of Alderman Volmer, who wasn't able to be here today. Then we'll move to Board Bill 110, and then finally we'll have a discussion on the Prop S funding. We need to have some things finalized by December on that. Just in terms of first steps, so just want to make sure that we all have kind of that roadmap laid out for us. So with that, I'm going to turn the chairmanship over to Vice Chair Aldridge while I present Bill 111.
All right. Alderman Orion, you have the floor to present Board Bill 111.
Thank you, Vice Chair Aldridge, members of the committee. This Board Bill number 111 is a board bill recommended by ENA and that authorizes the Fire Commissioner to enter into the 2023 Fire Prevention and Safety Grant Agreement with the U.S. Department of Homeland Security. It authorizes the Commissioner to accept grant funds, to appropriate the funds, and there is a required match for the funds. What this really will allow for is a 34-foot training trailer in which we will be able to create numerous hands-on emergencies that should help for training purposes. As well, there's funding for educational materials and handouts. And then I think potentially most importantly, when we're looking at it from through a public safety lens, over the course of 2 years, it allows for 3,000 smoke and CO2 detectors to be given to the community, as well as 7,000 long life smoke alarms. Those last for 10 years. So these are, the alarms that alert people that there's either smoke or CO2 in their home, and allow them to leave that home, which helps to prevent firefighters from needing to go into those places if they know everyone is out. With that, I'm happy to answer any questions.
All right. Starting in order of seniority, I will start with Alderman Oldenburg.
No questions. Thank you.
Alderwoman Clark Hubbard.
I don't have any questions. I just would like to add to be a I'd like to ask rather to be a co-sponsor. And my name.
You just do it in bang.
Yeah, I would like to make the motion that we pass Board Bill 111 out with a Board Bill 111 in bank.
Second.
All right. There was a motion to embank Board Bill 111 from the Alderwoman from the 10th, seconded from the Alderwoman of the 7th. Hearing no objections, Madam Clerk, could you make Board Bill 111 embank, please?
Noted.
Yesterday was the 5-year anniversary. Everybody knows how much I love the fire department. I really was supposed to be a fireman. Really, I was. But yesterday was the 5-year anniversary when I did a controlled burn down on with the fire department. It was an amazing, eye-opening, lightning, excuse the pun, experience. And it also reminded me that, to your point, this is good timing because with daylight savings time coming up, that's another good time to check or change your smoke and CO detectors. So thank you for bringing this legislation forward. Thank you, Alderman Ballmer, and thank you to our fearless St. Louis City Fire Department for all of the work you do daily. First in daily.
All right, Alderwoman Keys.
No questions, but a comment. It's very timely that this Board Bill 111 is on here. I literally just left from having lunch. I treated the new recruits from the fire department to lunch at Maggie O'Brien's. So this is something that I'm definitely in support of. And, I thank our fire department and all of our first responders for all of the work that they do and the fact that they are willing to put themselves in harm's way to protect us. And I'm very grateful. Thank you.
All right. Alderwoman Velasquez.
No questions, thank you.
All right. Alderwoman Sanye.
I don't have any questions. I would have just asked to be added as co-sponsor, but the Alderwoman of the 10th has already taken care of that for me, so no questions.
No questions for myself. Alderman from the 4th, you may proceed.
At this point, I would ask that we pass, I move that we pass Board Bill number 111 out of public safety with a do pass recommendation.
Second, or I make a motion that we pass Board Bill 111 with a do pass recommendation.
Second.
All right. There was a motion made by the Alderwoman from the 7th to pass Board Bill 11 with a do pass recommendation. Seconded by the Alderwoman from the 11th. Madam Clerk, please call the roll.
Alderman Otenberg.
Aye.
Alderwoman Clark Hubbard. Alderwoman Keys.
Aye.
Alderwoman Velasquez.
Aye.
Alderwoman Sanye.
Aye.
Alderman Aldrich.
Aye.
Chair Narayan.
Aye.
We have 7 aye votes.
All right, with that, we have passed Board Bill number 111 out of committee with a do pass recommendation. Next, we're going to Board Bill number 110. Alderman Aldridge, you have the floor.
Thank you, Mr. Chair and members of the committee. Madam Clerk, could you read Board Bill 110 summary?
Board Bill number 110, introduced by Alderman Rasheen Aldrich, an ordinance to repeal ordinances and sections within the revised code of the City of St. Louis relating to acts of public decency, offenses against public peace, and other miscellaneous offenses.
Thank you, Madam Clerk. To the chairman and members of the committee, today I want to present to you Board Bill 110. The scope and energy of the bill, Board Bill 110, is to get.
Can I stop you for just a second? I do see a committee substitute in front of me. Did you want to get that committee substitute in front of us and talk on that, or?
Yep, you beat me to the punch, but I will.
Okay. Sorry.
No, you're all good, Mr. Chairman. If I could adopt the committee sub in front of us to Board Bill 110.
Okay, yeah.
I move that we,
Go ahead, Vlad.
I was going to move that we adopt committee substitute 110.
Second.
All right, it's been moved by Alderwoman Velasquez, seconded by Alderwoman Keys, that we adopt,
Sonia.
Sonia.
excuse me, Alderwoman Saunier, that we adopt Board Bill number 110, which would put that properly in front of us. All in favor signify by saying aye.
Wait a minute.
Aye.
Do I have 2?
Opposed? All right, so now we're working on 110.
Committee sub, and you will see that. So there's 2 in front of everybody, but it is the one that says committee sub in front of you.
Okay.
So there's one that says Board Bill 110, that was the original one, and a little smaller, and then the thicker one is the committee sub. All right, as I proceed on Board Bill 110, committee sub as amended. Again, Board Bill 110 would ultimately start to repeal a few ordinances that we have on the books that are either have been ruled unconstitutional from the Supreme Court level or from the state of Missouri, as well as other unlawful ordinances in our books. So the first one, if I could start to walk people through each ordinance. The first ordinance on page 1 that we would be repealing would be ordinance number 54729, which is not being able to desecrate the flag within the state of Missouri, but we would be repealing that far as in the city of St. Louis. There was a court ruling back in 1989. It was Texas versus Johnson, and that was the United States Supreme Court that ruled that the Supreme Court ruled that the burning of a flag as a form of a protest is protected by the First Amendment. The judge determined that Lee Johnson acted as the flag burning with the feelings of conducting political messages which fell under the freedom of speech protection. Again, this was something that was ruled from the Missouri Supreme Court, not Missouri, the Supreme Court, United States Supreme Court, that the desecration of a flag is protected under the First Amendment. That was an ordinance that we have on our books asking to strike that out. Ordinance number 57249 is a vagrants ordinance, also another ordinance that was ruled unconstitutional by the Missouri Supreme Court, stating that the court decided that several St. Louis County laws that we also have on our books was unconstitutional for limiting unfair freedom of speech with certain improvements of public safety. These laws require that people to get licensed for certain bodies, the label people without a job or as a home as vagrants, that it could be ruled unconstitutional. Again, that was another Missouri Supreme Court ordinance that was cited in 2021. Ordinance number 69428 is mandating of mediation. The Missouri Supreme Court ruled that local entities could not tell banks that they had to go into mediation with personal individuals. It's actually a state statute that protects mediation that has to be done on the state level, and that state ordinance, for people that want it, is a revised section of 443.454 from the state level that says any mediation between homeowners has to go through state, not local municipalities. Section 15.142 of Chapter 15 gets interesting because when you actually look at this chapter or this section, there is no ordinance. When you look at the other ordinance, you can see when they were enacted on our Muni Code, but when it comes to these two sections, there's no ordinance. So there's a belief that both of these ordinances were struck down, but Section 15 said that it is illegal to bring any insane or mental person within the city of St. Louis. I mean, if you know somebody who is struggling with mental health, this was passed back in the day that if you brought them into the city, it would be rude, unlawful. The second one, Section 11.20 of Chapter 11, ruled that if any insane individual was sent to a hospital and the hospital took them down, then they would be in the custody of law enforcement. So not trying to put our law enforcement at risk, even though this is, I'm sure, both sections that are not followed in law to this day. We just want to clean up the books and take those out of the section. Section 16.08050 of Chapter 16 is saying that a judge can be able to keep you in prison if they believe that you will continue to be drunken. Nowadays, we have rehabilitation that judges put individuals through. This was saying a judge can keep you in prison as long as they think that you weren't going to be an addict. And we want to clear that up because there's due process. And again, our judges do work with a lot of individuals who have like mental health and not just trying to keep them in jail. Section 61415 is repealing the loitering ordinance. So currently right now, if an individual wanted to, or a business owner, a private business owner, keep a loitering sign up, they would be able to. But what this would do is repeal it because we also found that there are other charges that law enforcement can use if somebody is on private property and the owner is asking them to leave. There's other things such as trespassing that we found law enforcement can use, as well as looking at the stats of SLMPD. So they group vagrancy, loitering, and curfew all in one. And in the last 3 months, on July 2024, there was only 2 reports of loitering. August of 2024, there was only 3 reports. In September, there was only 7 reports. So instead of having something on the books that is typically not used within our law enforcement, there's still the ability for, if a business owner feel that an individual is staying on their property, that they could use trespassing. But there's also arguments that have been made if somebody's on public right-of-way that isn't necessarily loitering, but the Fourth Amendment for them to be able to walk up and down the street. And then the last one is amending Section 15.34030, which will put penalties in place, but more second chance violations for individuals who may be in a neighborhood or in a community necessarily doing like prostitution. So as you see in the bold, we end up putting, if any person is found guilty of this first violation, they would undergo some type of counseling and rehabilitation. Again, the goal is not to, in their first offense, to try to penalize individuals who may need the most help, but to try to rehabilitate them. In the second sentence in B, you will see there is still a fine and also a 90-day imprisonment if this was to be found again. But ultimately, what we're trying to do is make sure when persons undergo some type of arrest due to prostitution that the first reaction isn't to jail them, but to try to help them. And what we also know in the state of Missouri, former Senator Nasheed used to always hold these sex trafficking awareness rallies in the state to talk about how a lot of individuals are, either forced into this and then found to be constantly criminalized and arrested multiple times. So I know I said a lot, and I know there's some questions, so I will yield to any questions from my committee members of the committee.
Thank you, Alderman. I'll just open it up to the committee. Alderman Oldenburg, any questions?
Thank you, Alderman. Just broadly, did I miss some policy memos, some broad directive, some new initiative in the city councilor's office or other that is stating kind of broadly that we're going to clean up antiquated laws and ordinances and that we're going to actively modernize and streamline our operations with a strategy of achieving more updated laws as a pretext to potentially getting sued?
No, I would say this is probably this is the third iteration that the Board of Aldermen, not necessarily this bill, but this is probably the third bill that the board has passed when it comes to cleanup of laws. I know Alderwoman Spencer did some cleanup around the legislation that we wasn't using anymore with women's choice to choose, and I believe there was a recent one. We did a barbershop cleanup language and red tape of cutting legislation that was holding individuals back. I would say this is kind of part of, not that I worked with them all together, but part of the same spirit of cleaning up laws. The first 3 laws and ordinance that I cited was ruled unconstitutional and illegal from Supreme Court that is still on our books. The second and the third one as well. And then when it comes to Section 15, when it's talking about insane individuals, I think that's a outdated thing. We shouldn't be charging individuals for bringing somebody in the city who may have mental health issues, as well as not giving them the proper treatment, Section 11, and turning them away from the hospital.
Thank you, Alderman. I would certainly agree that some of those terms aren't used and probably aren't also terms of endearment that we should be utilizing. when we're talking about people who need to be rehabilitated. So I'll certainly concede some of the wording feels improper and insensitive. But I hate to get tripped up on whereas clauses, but I have trouble casting an aye vote and moving forward, because I think there are a lot of pieces in here I agree with, but with some of these whereas statements whereby I don't have sort of an opinion of the city councilor's office. For example, the third whereas clause that says certain provisions within Title 15 of the City Code are inconsistent with current legal standards, leading to the potential legal challenges and administrative inefficiencies. I'm not saying that that may or may not be factual, but making a statement like that, I would love to have the legal community maybe opine that we do in fact have irregularities or inconsistencies that are unconstitutional when making a statement like that.
Yes.
I'm just curious if there could be some insight gleaned from the city councilor's office that they believe that whereas clause.
Yes. Well, I would say we do also know whereas clause isn't the actual structure of the bill. I mean, it is part of the bill, the structure of the bill, but that is not what would be what we're doing here today. And we can get an opinion of the city councilor, but I would also say that, again, when it comes to the first three ordinance that we are repealing, I mean, I'm not a lawyer and I'm not the city councilor, but the United States Supreme Court ruled the flag burning illegal, as well as the other two that was ruled by Missouri Supreme Court. So
those three, just to remind me, so yeah, flag desecration, I don't think anyone's disputing that. That's been around long enough as law. Vagrancy was the second one, and the third one was mediation.
Mediation, yes. That was also ruled by the Supreme Court, that local.
So, thank you. I appreciate that. So I appreciate bringing case law, and I think you're right. I think everyone knows that's pretty settled law. Those three items you brought up. I noticed that loitering, though, you did not cite any case law, but made the leap to say that, well, other tools can be utilized by the St. Louis Metropolitan Police Department vis-a-vis trespassing or others. I personally like to think that loitering, even though it's on the books and we maybe don't utilize it, is still another tool where police officers can use discretion in concert with business owners and other proprietors in the city to move a potentially unsafe situation away or have it mitigated. So is there any specific case law that we can glean insight from around loitering ordinances?
Not necessarily any case law. I know not in this state. I know there's case law in Chicago, but we're not Chicago. We're St. Louis, where loitering was ruled unconstitutional or illegal after a court case between Chicago and Morrison in 1999. But the goal of loitering is not to not give the ability for law enforcement to be able to support businesses. If somebody's on a private business and they're not allowed, or the owner told them to leave, there are charges such as like trespassing. And what we've seen as we went even back all the way within a year of, and all of this is public knowledge on SL Police Department surveillance data that they recently released, which is a nice portal. There's very few times that loitering has an officer has stopped somebody from loitering. I think if anything, our department has shown that, you know, they try to communicate and try to get somebody to move or continue to move if it's on a private property, compared to just standing on a sidewalk. That gets into question if a person can be on public right of way, which isn't a crime. So trying to allow our local law enforcement to not get caught up, I think, in another check off the box, but actually use tools that are actually effective to move people from private property. And I know that's kind of your point, if it is necessarily for them to be.
Sure.
And it doesn't also still stop a private business if they wanted to keep their loitering sign up, to inform people like, hey, just don't hang out front. But if they are hanging out front, again, that's trespassing, which holds a charge.
So what's if I'm hearing you correctly, the virtue of removing a loitering ordinance is simply just because we're not enforcing it? Or is it that there's a potential pretext to it being unconstitutional, or it opens us up to lawsuits, the fact that that law is on our books?
I would say a little bit of both, knowing that Chicago has already ruled this unconstitutional. We don't want to be the next one to lawsuit. We can't predict that. It's always good, instead of being reactionary, and not saying that you are at all, Alderman, but, how do we be proactive to see how other states have responded to loitering? And again, I think it's, as you just look on the data, it's one thing that is not currently
Yeah.
police spending resources on trying to stop people from loitering, again, if a business call for trespassing. But this is one of the resources that we just haven't seen in the last year on the data that is necessarily being used by our law enforcement.
Okay. I'm glad you brought up sort of, I think that's a valid point. I'm glad you brought up sort of being proactive. And if the logic holds where something that's either not enforced and not utilized and could potentially open us up to litigation, right? That the logic would dictate, well, then we can remove that law or ordinance. Do you think the same logic applies to proactively enabling a law after a recent Supreme Court ruling or other court ruling? In other words, something becomes a new precedent by a court. Now, therefore, a municipality can enact an ordinance or law. You think that same logic applies to what we're doing here in terms of removing an ordinance?
I would say it depends on what Supreme Court is ruling. If Supreme Court is ruling Roe versus Wade and enacting that, I would not encourage the city to enact those same laws. I would hope that we would abide by the Supreme Court ruling. So I think it's a mix of, I think each one depends. That's why I think the top three have already been ruled, unconstitutional. And being proactive to make sure that we don't get caught up in a loitering Supreme case. And I said Chicago, there was actually a Supreme case court ruling, that we don't get caught up into potential litigation. I think doing it on the way we're doing it now is saving ourselves compared to every law that Missouri Supreme Court in a red state, or depending on, hopefully not this election go crazy,
Sure.
What those laws may be to enforce us to enact those. I think if they are enacted, we must follow the law. And I think if they have been ruled unconstitutional, we should follow that, but also be skeptical to make sure that we don't have things on our books that could get us later down the line, caught up in litigation.
Sure. Are you familiar with the recent Supreme Court ruling, Grants Pass versus Johnson?
No.
Okay, so that was the ruling sort of toward the end of the summer that the Supreme Court ruled that municipalities could in fact make encampments illegal, and that it would not be a violation of the U.S. Constitution. Eighth Amendment, yeah, thank you. Would you support an illegal encampment ordinance based on that Supreme Court ruling, knowing that now the municipalities can utilize tools to keep the general welfare and public safe?
I believe that we will have to follow the law, and if I'm not mistaken, I think what encampments are, is it federal and state land or city property?
Okay.
That was a question, since.
Yeah.
I think
support, based on that Supreme Court ruling, the tool for St. Louis to, as a municipality, to make encampments illegal.
Well, it's not encampments completely. I think what that ruling says is on certain properties.
Camping in public rights of way or other public property, right?
Yeah, and I think
making that illegal to pitch a tent on a sidewalk and stay there for a duration of
if the sidewalk is public, I think that would be a conversation that we would have to look at that. But already believe that we would follow that law. We know that recently that was, yes, and the state also passed legislation that says that encampments can't be on like federal land. I'm not sure if it says in that ruling if it's city land, but that would be something we would have to look at. And if it's already a law, I would assume that we would abide by it.
Got it. Okay, that's helpful. Thank you. And I apologize. I do want to keep going a little bit if I can.
Take your time, Alderman. That's what committee's for.
Thank you, Alderman.
That's what committees are worth or about.
Under Section 8, and again, I think I'm in agreements with repealing paupers and insane persons, habitual drunkenness, and drug users. I think there's the terminology and the ability for ordinances, hereby that I don't take much issue with. But when you strike language, and I'm on page 2 of 3 of the committee substitute, line 8,
Mm-hmm.
which is, this is pertaining to prostitution, correct?
Mm-hmm.
That's 1534.030. Yes. Penalty for prostitution, fine. Shall be in violation of this chapter for any persons to commit prostitution, public solicitation, or patronizing prostitution herein defined as, and then you strike, it shall be a violation of this chapter for any person to be found in a place contrary to any court order that prohibits the person from being in any specified area as a condition of release from custody, are under court supervision, parole, involving prostitution, public solicitation, or patronizing prostitution as defined in this chapter. I just want to make sure that the removal of that doesn't impact any other potential court order or ruling or probation or neighborhood order of protection specifically for that. And I will say, I'm bringing this up sort of also as a clarifying statement, I did ask our attorney at the Board of Aldermen if that was the case, and he said no, that if there was a other neighborhood order of protection that exists, someone could still be in violation of an overall neighborhood order of protection if they were in violation of prostitution, and part of the specific prostitution charge said they could not go back to that area. You're removing that, but of course, if there's a neighborhood order of protection, that's still a tool the court can utilize overall, is what was confirmed there. I want to sort of further flush that out, but.
And the goal of that also is not to just limit some of these AB that we're changing only to those also neighborhoods as well, because those are certain zones. So we actually was trying to expand it, but it wasn't to stop individuals who have a neighborhood order not being able to go into those, but also, like I said, expand it out because those are only certain zones that would be within that order.
Yeah, but what was the reasoning for eliminating this specifically? And granted that it can be captured by another court order or ruling of neighborhood protection, but why wouldn't we want the municipal court to say, you've been found here soliciting prostitution 3 or 4 times in this area, you can't go back there for a certain period of time? Why would we want to specifically?
I think also what we had found as we was working on the legislation, same as I think our city councilor, it was proven that if a court order says that they couldn't go in that location, they still couldn't. And I think the goal, like I said, when we looked at it, was not trying to limit, but expand the scope to beyond just that neighborhood or that zone.
Okay. Oh, I see. Okay. And then adding the clauses A and B that you do, right, that we find services and diversion, right, understanding that too. No disagreement there. But then also, striking the court can no longer determine whether the violation occurred within a school zone, a church zone, or a park zone as defined. And I think those are just sort of, American apple pie areas that people tend to think they want to make sure if a judge says the penalty is going to be enhanced or you can't go back to those areas. I guess your same answer or logic applies there, that it's really just removing the specificity.
To certain limitations of where they couldn't be, yes.
Okay. My last question is page 3 of 3, line 4, the changing of shall is being struck to may, which I believe allows more discretion with that word change in the legal community. So why would we not mandate that for the purposes of determining the presence of any sexually transmitted disease, HIV or other, that the cost of such testing shall be taxed to the defendant as a cost of the proceeding. I mean, we're going to want the individual tested, right? I mean, I think law says that has to happen. If someone's found in violation of soliciting or engaging in prostitution, that they then need to be tested for the safety of their family, potentially, or others. Why wouldn't we mandate that in keeping the word shall?
So the thought behind changing it to shall and to may is to give discretion. Some people, when it comes to prostitution, not that they wouldn't get tested. I think it's also still a lot of stigma around it. And if they are forced into it and end up getting, catching this disease, again, the thought was to try not to shame people, but allow the court to give individuals discretion on how that will be able to move forward. I believe every court will still move forward and say, hey, you have to go get tested, but I wouldn't also, depending on each case is different, and wouldn't want the court to be forcing individuals to do something. I wouldn't say forcing individuals to do something, but give the discretion to the judge to be able to make the decision. Still, at the end of the day, lies within the judge.
Okay. I mean, my personal opinion is why allow discretion of the judge in that case, right? I mean, overall safety and the spread of the sexually transmitted diseases is paramount to public safety and the overall health of our city. But I certainly recognize your point. I just happen not to agree with it. I don't have any further questions. Alderman, I'm not going to support this today. I'm going to vote no, but if you would find some flexibility in and around the loitering ordinance, keeping that on the books, and maybe working on some of the language around the neighborhood order of protection just to make sure that is in fact solidified and that we're not creating any pitfalls there. It's something that I'd be happy to sign on to and support with you at the future.
I appreciate it, Alderman.
Sure. Nope, nothing further.
All right, let's move to Alderman Clark Hubbard.
I don't have any additional questions. A couple of the questions I did have, Alderman Oldenburg asked. So I'm going to wait and hear from my colleagues on the board to see if anything else arises that I would have concerns with. I do thank you for this, bringing this legislation forward. We know here, again, there's so many things that we do need to bring up to date down here and in our city. So again, I was just now listening to my other colleagues and see if anything else arises. I'll definitely raise my hand.
And if I could jump in, Mr. Chair, to your point, Alderman Oldenburg, on that last, when you got all these notes and trying to make sure I juggle them all, on that last May, so it is state statute, chapter 567, section 567.1204, where it says HIV testing for a person arrested for potential prostitution related. In the statute, it says may within that one as well. So it would be in line with the state statute from changing it to shall to may.
Okay. Thank you for pointing that out. I would still disagree with the state statute, but thank you.
No problem. Appreciate your questions. You too, Alderwoman.
All right, let's move to Alderwoman Keys.
Thank you, Mr. Chair. I have to fall on the side with Alderman Oldenburg. With the loitering, my personal opinion is that that is not your sidewalk. You know, you're responsible for it. You know, you have to replace it through a 50-50 program, or, you know, if the city's going to replace it, you're responsible for that sidewalk, cutting the grass on the area that is closest between the curb and the sidewalk. And, you know, this recent situation that occurred in South St. Louis where, you know, a family basically set up housing on a sidewalk in front of a homeowner's home, and they were unable to move them. I believe they probably ended up having to get an attorney. I'm not necessarily up on the end outcome that they were finally able to move off of that sidewalk. If that is going to be the position of the city, then no one should pay for sidewalk removal or replacement or repair. Because again, it's not your sidewalk. If somebody else can come in front of your house and set up their housing. With the prostitution thing, I recently spoke with one of our officers who informed me that St. Louis City Metropolitan Police Department no longer has a vice unit. I have seen a tremendous uptick of prostitution in my community. In fact, just down at the end of my block, we had to declare a home a nuisance and have that activity shut down. And I think that if you are participating in those activities, yes, you should have to be tested. At that point, I'm not concerned about whether you feel ashamed or put out there or not. You're putting other people at risk. When we look at the HIV numbers for the city of St. Louis that continue to climb, as well as other forms of sexually transmitted diseases, this is very, very necessary. I believe that this requires more discussion and possibly further research by whomever the legal team is, and maybe vote on this on another time.
And if I could respond to Alderwoman Key, so what you're stating far as the encampment being set up on a sidewalk, again, that, as you said, they couldn't do anything because that wouldn't be considered like loitering. There are charges that can be made, such as trespassing, which our law enforcement use more of. Somebody just standing on a sidewalk also can get into a conversation of, their constitutional right if they were just, having a cigarette on a sidewalk and someone call and say you're loitering. It isn't to stop encampments. I think there's other practices and ways that our police department move forward if there's an encampment, and I think we have at this board continue to try to figure out how do we remove them, and I know the city hasn't gone in to remove them on the brinks of Ordinance 61415 as far as loitering. There's been some breakup of encampments, and they used other ordinance to be able to do that. So this doesn't, loitering wouldn't address if somebody's just standing on the sidewalk. If it is in front of somebody private property and that easement is their property, that is a trespassing charge that could be used. As far as the prostitution goes, again, if you're commenting to what Alderman, I think, from the second brought up with the may to shall say must get tested, again, that's state law that we are saying we're following by saying may instead of shall. So we're following the state law that is been brought by the state of Missouri to make sure that we're in sync with state. And I can read that ordinance for you again if you would like to
You don't need to
reference.
repeat it, but I think that this needs further discussion, and it may need to be fleshed out a bit more.
Heard.
Anything further, Alderwoman?
No, thank you.
Okay. Alderwoman Velasquez.
Thank you, Mr. Chairman. And thank you, Alderman Aldrich, for bringing this bill up. I just have one quick question. I know that we had talked about this bill previously. Given that, does this bill, I know it's repealing lots of different things. Have you given any thought to it? Does it fall under one single subject?
Yes, sir. We asked Lou Galley. We asked our city councilor about it. So yes.
Okay, that's my only question. Thank you.
All right. Alderwoman Saunier.
Thank you, Chair. Alderman, I do have a lot of questions. This bill is very ambitious. So first of all, I just want to thank you because thanks to you, I spent hours digging through state statutes and city codes and trying to have an understanding of like what you were proposing, because I certainly think that on the surface, I just saw so many things being repealed at once that, my antenna certainly went up. And for me, I think probably for all of us, I always want to be prepared because I know that this is something that I will be asked about from constituents, and I want to be able to guide them. So I just want to ask you a couple of questions for clarity purposes and
Yes,
making
ma'am.
sure that, you know, the due diligence that you put in, I'm understanding what it is that you're saying and where it lines up. I do want to also start by saying that I'm glad that you ran for office, and I'm glad that you're alder, and I think that legislators have a responsibility to legislate, and that should involve, obviously, I think especially for someone like myself who is extremely interested in policy, like we're gonna dig through codes, we're gonna do research, we're gonna try to bring it up to date, and I don't need a city councilor or a mayor or any other city official to tell me that that's the direction of which we need to do. I think that's something that we have the right to do, and I encourage us to do it, especially knowing how many things are antiquated and outdated in our city. So I want to, I guess, along your general question, I want to be clear. It seems like a lot of questions are about the Is there anything in your bill that is specific to the unhoused issue or any specific city things that govern them?
Not in this legislation, no.
Okay. Okay, and the chapters that you're proposing we repeal that are specifically related to legal issues that the U.S. Supreme Court or the Missouri Supreme Court declared to be unconstitutional.
Correct. Section, or ordinance number 54729, again, was Texas versus Johnson, U.S. Supreme Court. The other two is Missouri Supreme Court.
I'm gonna go through section by section, just make sure that I'm correct.
Okay, yeah. So the first one was United States Supreme Court ruled that
Texas versus Johnson.
Texas versus Johnson, yes.
Okay, and this was the United States Supreme Court that said that this is, you can't do that, and so you're just trying to line us up with what the United States Supreme Court has said.
Yes, ma'am.
Okay, section 2 talks about the repealing of the criminalization of vagrancy, and I just want to make sure I'm clear in understanding that this was struck down by the Missouri Supreme Court under Fernandez versus St. Louis County in 2021.
Yes, ma'am.
Okay, section 3 repeals the foreclosure mediation requirement, and I want to make sure I'm correct in understanding that this was struck down by the Missouri Supreme Court under Missouri Bankers Association versus St. Louis County in 2014.
Yep, and that is section 443.454 in the Missouri Supreme Court statute section.
Okay. Section 4, the criminalization of loitering. Obviously, I'm a little familiar with that section. I had anticipated that would be something that would be the most, but I guess for me, I just want to make sure I'm understanding your legal framework, because I think that was, out of all the things on here, the one that was the hardest to find a legal framework. And the only thing that I could really find was that the U.S. Supreme Court in 1999 under Chicago versus Morales struck down a loitering order. And I think that, from my understanding, their reasoning was a law fails to meet the requirements of the due process clause if it's so vague that its standards leave the public uncertain as to the conduct it prohibits. So I guess for me, I want to make sure, is there any other legal framework or any other references that I can find around loitering, or is that what you were looking to?
I mean, it was that one, as well as, like I say, we looked at data going back a year of what is on the St. Louis Police Department webpage for us, how they use loitering. And what we've seen is they don't use this as a statistic as much anymore. Very few numbers. I think they, like I say, are using resources in different ways to be able to stop somebody from blocking a sidewalk by just saying, hey, I'm having a conversation with you. Like, continue to move on. If they don't show ID, there's charges for that. If they're, again, trespassing, that is like the number one charge that law enforcement typically would probably use if somebody is blocking a walking right away, or maybe somebody's just standing there. But when it comes to private property, the owner can always request like trespassing.
Thank you. And then section 5, you're repealing the prohibition on bringing paupers and insane persons into the city. And from my understanding, and maybe I was reading this wrong, it looks like that entire chapter was already repealed.
The entire chapter is not in the city ordinance anymore, even when we tried to get the registered number from the register. So when we went to the register working on these other ordinance, she was able to provide us with those. She wasn't able to provide with those two when you look at the Muni Code, you can tell at some point it was repealed, but these sections never was taken out of the Muni Code. So the whole ordinance that carried these sections no longer exists, but still exist within our code.
So is it your understanding that perhaps these sections were accidentally left behind when the entire chapter was repealed?
I would say that people work really hard to keep our codes up to date, and I think they tried. I think that's why we use ARPA funds to change our whole like zoning code and all our codes, because it's a lot of things that we add a lot of times to our code, but we don't go back and do cleanup to see if it makes sense, i.e. like the Charter Commission, to make sure that either things are legal, things are up to date, or things just that don't exist anymore are not still within our code.
Okay, and then Section 6 repeals the section entitled Insane Persons. I worked as a mental health advocate for years. I have a strong background in that type of work and in those types of services. So I do understand that, referring to insane persons is outdated. It's kind of discriminatory language, honestly. Mental health professionals and people within the legal field, we try to avoid those words, specifically if they haven't went through psychological testing and assessments. We don't want to be categorizing people as things if they haven't been tested as them. But again, I just found this one interesting again because a lot of it was already repealed. Is that correct, or am I reading it wrong?
It was both of those, section 15 of chapter 15 and section 11 of chapter 11 was both repealed. Section 5 and 6 of the bill was both repealed.
And I just
already taken out, but left within our zoning code.
And then
our Muni Code, sorry.
That's okay. And then just for my colleagues, I just wanted to read a specific part that is of concern to me, because thinking of folks who might be in mental health crisis and what this ordinance says, the language specifically says that a person experiencing a mental health crisis shall be given over to the police for such action as they may find necessary. And I even know that the St. Louis Metropolitan Police Department have started a whole, we have a whole special division so that there can be social services, and so that the first route doesn't necessarily have to be a police response. And as someone who has had to work with folks who are in mental health crisis, I know that sometimes police their presence can aggravate or escalate the situation. And I've seen officers themselves want to know, is there another resource, or can I go in with a partner? So I just wanted to make sure for my colleagues that I just put, to me, I think some of the danger of that language is just mandating that they be passed over to police, because there are EMS responders, there are several folks who can respond to these incidents. And I think the city has actually been putting these things in place so that police don't have to be our sole and only response. Again, not ever saying that it's never a case where you should get the police resolved, but just saying that it's not always a case where you should get the police involved. And also just want to also note that in the event that the hospital rejects a patient, or find that they're not at a certain level of crisis, which does often happen after police make arrests, it just makes for a tricky situation. Section 7 repeals the section on criminalizing habitual delinquency. Can you elaborate on that? I guess, from my understanding, you're trying to give a municipal judge the discretion to jail no longer than a year for habitual things. And again, I want to make sure I'm on the same page as you, because you're talking about habitual delinquency. So you might be talking about habitual arrest for substance use treatments, habitual arrest for a mental health crisis, and you wanted to make sure that there's discretion for a judge to evaluate that and take that into stance and be able to exercise discretion.
Yeah, the whole point of that language is what currently is on our books. It gives judges, in which I think all our judges are trying to rehabilitate people. I won't say all, but I think that's the direction, like we're moving in courts, and judges just not are locking you up, and actually trying to, give people second chances. But this one on the statute says if, a judge can keep you imprisoned until they find you not to be drunken. So it's no clear understanding, instead of also trying to, like I say, rehabilitate and help somebody out. So getting rid of that language, so it doesn't allow judges to which I don't think they will, but hold people longer than necessary of trying to help rehabilitate them.
Yeah, I know as a mental health advocate, a lot of times judges would specifically use like a drug court or something like that so that they weren't in situations, I would have clients or patients that would be in jail and actively going through detox and like probably would have died if they weren't able to get access to some of those other resources. So I just want to make sure that you're trying to create a situation where people are not jailed for their addictions, get pathway to another source of treatment.
Yeah, like you say, we have jail court. So a lot of time, or drug court. A lot of time, these situations that occurred, somebody who have been through drugs, they go through drug court, and there's proper channels that those judges go through to make sure people are getting, necessary counseling or rehabilitation compared to, again, some old language that's been on the books for a long time that says that a judge can just keep you in jail too. They feel you're not drunken. Literally is what it says in the section anymore.
Okay. In Section 8 amends the city's prostitution ordinance, which is very bold. So for me, when I look this up, I do feel like my constituents have varying thoughts and feelings around prostitution because, obviously I understand that, a lot of people who are either prostitutes or sex traffickers, because a lot of times you can't tell the difference, that they have kind of been victims of circumstance in their own right. But I think, to some of our colleagues' points today in terms of their interactions in communities, in terms of how they impact people, I can see this being something that people have just nuanced feelings about. So I don't want to get too deep into what you're trying to do. What we spoke about was I asked you to make sure you aligned yourself up with state statute. And so I just want to be clear that for this specific section, this would now delay to state statute, which is state statute that has the may language, whereas the city has shall, and we're actually enforcing tighter than the state does, which I don't believe we're allowed to do.
Yeah, and I mean, that is something that definitely can, continue to have like conversation with colleagues on. Again, that was to align with the state language to make sure that, coming from the state, our state tends to be a little bit more stiffer on penalties and just being tough on crime that continues to not change things. And with this was to follow the state law and not to be as, I guess, more tougher than what the state is already demanding of us.
Okay, I think that's important because for me, I can always explain to a constituent that the state law trumps anyway. So right now, whether it says shall or may, the state law will, take precedent over ours and it will be shall because that's what theirs say. So if you're just trying to bring us into compliance with the law that trumps ours, I'm with that. Let's keep us in legal compliance, and that makes it a lot easier to have this conversation. I guess along those lines, to your knowledge, does the city councilor's office prosecute a lot of prostitution cases? Do you have any information on their rates of those and if we're convicted in those cases?
No, we did look to see as far as like prostitution from the city and have not got any data that we like moving forward on those charges. I think we have, or prosecuting charges. I think the city is kind of dealing with other things, earnings tax and a whole bunch of other stuff. And no, we do not currently go after prostitution.
Okay. And then just to circle back to this may language, I want to read that the state statute says the judge may order a drug and alcohol abuse treatment program for any person found guilty of prostitution, either after trial or upon a plea of guilty before sentencing, or the Class B misdemeanor offense upon the successful completion of such program by the defendant. The court may, at its discretion, allow the defendant to withdraw the plea of guilty or reverse the verdict and enter a judgment of not guilty. For the Class B felony offense, the court shall not allow the defendant to withdraw the plea of guilty or reverse the verdict and enter a judgment of not guilty. The judge, however, has discretion to take into consideration successful completion of a drug or alcohol treatment program in determining the defendant's sentence. So I just wanted to make sure that for the record, the actual language that the state statute says is there, and just explain that a lot of times the reason why that language is like that, I've seen this play out in courts as a mental health advocate, is because judges will choose oftentimes other routes. So whereas we might be thinking, well, of course you're going to send that person to a clinic to get them tested, a lot of times, especially if you're thinking about where you might have someone who might have been sex trafficked, where you might have someone that's like severely drugged out, yes, they're going to get tested eventually, but a lot of times judges might opt into more holistic wraparound long-term programs that like testing is a part of what you will do, but there's also counseling, there's also safety parameters if we need to make sure that, you know, the person who is pimping you out cannot access you, if we need to make sure that the people who are trafficking you, that you're able to get distance. So I just wanted to really share some of that information with my colleagues about why that discretion is there, because I have seen that play out firsthand as a mental health advocate. And so it's not at all to derail testing or to say that we don't want testing, but it's to allow for judges to have opportunities to choose other programs that almost 90% of the time will involve testing, but will also involve some of the protections that some of the folks who are doing prostitution or sex trafficking or sex work will need because of a number of other factors from safety to substance use. So I just wanted to kind of talk about how I've seen that state statute play out in real time and explain that it's not because people are not going to get tested. It's because there's oftentimes just a lot of other things and services that need to go in conjunction with that, and also safety a lot of times for those types of folks who need to be honestly protected from their pimp, protected from who is check trafficking them, sometimes might need to be taken to another area for the purposes of safety, that those language, like you'll see that all across the country, language like that to allow for judges to use that discretion.
And to clear up, want to be clear, yes, like when you said city councilor, I guess, yes, the police department do work through with the city council, but also Gabe Gore when it does come to charges. So it's not like the city is not doing anything when it comes to prostitution. Yes, the city does make efforts through our police department who work hand in hand with the circuit attorney to try to ensure that if there's prostitution, that there are ways to hold them accountable. But I think what we're saying is, how do you also, we can just say, oh, if somebody's having sex down there, it's easier said than done if, you know, it's also, like you say, a pimp or abuse. So trying to figure out ways of rehabilitation instead of just imprisonment. So there's still accountability for it. It's saying, how can we do rehabilitation and not just jumping straight to imprisonment for women or men that are being sex trafficked and used as prostitution. So yeah.
Yeah, I think I totally hear what you're saying, and I think for me, as long as we are following state law and we're not trying to set it ourselves, and I can point to something and say, hey, this state law says may, this state law says discretion, I'm okay with it because their law trumps ours anyway. So even if it went to court, that would be what we had to honor. And I just did want to commend you because I think what I see is that you're trying to create a lot of pathways where a person who is maybe arrested for the first time for prostitution can get access to some of the mental health and substance use counseling, you know, that can be very helpful to them and that oftentimes they are in dire need of. And so I just wanted to just lift up to me, it looks like maybe that's what some of your amendments are gonna do. And then I would just say maybe for the committee's sake, I think it might be good to, and I would be willing to help to create like a little FAQ or a little memo where we could show our colleagues, hey, here is what I'm trying to repeal and here's the direct Supreme Court case or U.S. Supreme Court case that says it, so that we can all be on the same page, because it did take me at least a few hours to kind of dig through everything and process everything and match it up. And so I think that us all having that clarity would help us to make our, take a vote that is informed and be clear on what it is that you're trying to do. Because like I said, the bill does on surface look very ambitious, but then once I dug through it, I was like, oh, he's just really matching us up with what the U.S. Supreme Court says. And I know we lifted up the Grants versus Pass case, so obviously we care about what the Supreme Court lifts up and says, and so they've said these things, so I think we should hold that consistently. Thank you.
Thank you, Alderwoman. So, yeah, I have a...
Alderman.
I was saying.
Oh,
I was referring to Alderwoman Saunier. But, yeah, I think just to tag on to the Alderwoman's thoughts, we tend to do these cleanup bills after a major shift, like when marijuana legalization came, we had to go back and take a whole bunch of things off the books and just change the way that we looked at things in our municipal code. But oftentimes that's just not the way that the law works, where you get this kind of seismic shift overnight. And I think what you're trying to do here is to address a whole lot of things that, you know, baby steps along the way have come up, you know, with flag desecration, as the alderman from the second pointed out. That's been settled law for decades. You know, I hate to see anyone desecrate the flag, but the best reason not to do it is because you're allowed to. You know, I think that's an important part of the First Amendment, so I have no issue there. I think in our in all of our neighborhoods, we probably have folks who may fall under that habitual drunkard language. That, you know, that means that a municipal judge could just lock them up indefinitely if that was still the case. I'm glad that that's not there. With prostitution, you know, the state does prosecute that. It's a B misdemeanor. The thing about that has always been that, to me at least, for folks engaged in prostitution, it seems like the penalties certainly affect some of them more than others. For me, this is much more of a women's issue and an LGBTQ issue than it is a me issue. So I want to certainly hear other voices on that when it comes to you know, those potential penalties. I do share the alderman from the second's concerns regarding both the effect on any neighborhood order of protections, as well as the STD, STI testing that would come into play. I think, as Alderwoman Keyes pointed out, we do have, just as a region, higher incidence of STIs than many other similarly situated places. I think this may be a kind of choke point that we could look to address that. I think that most people don't want to intentionally infect anyone else with anything, but you have to know to be able to make those informed decisions. I do agree that diversion is almost always more helpful in preventing further bad acts than simply saying you broke the social contract, now we put you in a room for this long, or you give us this much money, without ever actually identifying the underlying issue. And I think particularly on something like prostitution, where people get into that line of work for many different reasons. Some choose to, and some it's an absolute act of desperation. And I think to be able to control for that at the time of arrest and have a judge be able to say, hey, you're one of those people who would really rather not be engaged in this line of work. What can we do for you? Rather than let's throw the book at you. I think that's really important. And I think that would be a fantastic way to address this. Like I said, I do just share a couple of those concerns, but I think ultimately the vast majority of what this does is just bring us into compliance with where the kind of where the Supreme Court and where the state has said that we need to be. So would you be willing to work with me moving forward, particularly on the neighborhood order of protection concern, the STD concern, and then the loitering? I'd just like to dig into that further as a whole, because I agree with you in part that if you are loitering, typically the trespassing is what. If the police came to my house because someone was just hanging out in the front of it doing God knows what for no real reason, I would want them trespassed. I wouldn't want them to be issued a loitering ticket, because I wouldn't want them to come back. And if they did, I would want the police to be able to act on that right away. So I actually see trespassing as a much stronger tool to address that sort of behavior than loitering. But I'm hearing from several of my colleagues that, you know, they want to see the loitering piece still there, and I want to hear more of why, basically. Would you be willing to work on addressing those 3 points, or any of those deal breakers for you on this?
No, I mean, I don't think, you know, as we always say, legislation is always meeting in the middle. So I'm never in a mind frame of that, you know, we can't work together. I agree. I think most of the things that are being addressed, which if that information, as far as just like the state statutes, can be sent to colleagues, I can absolutely do that. I think, like you say, the small hiccup, and I wouldn't say small because I think all my colleagues' concerns are important, so don't take that any way. But like you say, willing to look at loitering, again, the thought behind that was, again, looking at the data and seeing what we use and what we don't, and how do we, like you say, I would believe that more law enforcement officers use trespassing instead of loitering. And then I know I talked to the alderman before the committee on some of the language around the prostitution that may have been struck out, that definitely willing to have that conversation. I think since it's, you know, and then I think the last strikeout is the school zone and the church zone, which I don't think seem to be an issue. Willing to work with colleagues through the process. Would love to take a vote on it, knowing that we would still work as the legislation move, as we've done that with many pieces of legislation on the floor, even when we thought we got it right in committee and still made changes. So, you know, definitely have my commitment there to work with you and any of my colleagues before we ever get to a place that is perfection without actual changes made from colleagues.
All right. Well, you know, it's your bill, Alderman, and I trust you to understand where your vote count is. So if you'd like to have a vote on it today, if there's a motion and a second, you're more than welcome to, or you're welcome to hold it to put more work in. I'll leave that completely up to you with what you'd like to do.
Any other questions first from my colleagues?
No, nothing from me.
I guess I will ask a question. Just for transparency, because I know I reached out to you that because he's calling me, so he might be watching. Well, he's not watching if he's calling, but I reached out to Judge McCoy just to get some clarity on that too. And it was shared with me that you might have met with Judge McCoy or speaking with him about this legislation. I think it would be good to share that part, because that was one of the questions that that came up after during conversation here with our colleagues. So if you want to speak to that, if not, or whatever, you're going to move forward. But I did want to offer you that, since I love, again, where this happens in committee and having the transparency. And I did reach out to the chair about that. And Judge McCoy, if you're watching, I did get your call, but I can't answer.
Yes. So I do know, and always this is my tag team partner who's not here right now in the moment. I do know that Janika from the president office did extensive review, so this wasn't nothing that we've been talking about for months. And I know she met with the judge on some of these ordinance, and just wanted to make sure that we was in line. So I don't know the personal conversation, but that was a conversation with her and the judge now. And I think you're probably getting confused. To be clear, we met with him on the jury trial legislation. That, yeah, different, yeah, working on.
Yeah. Go ahead. Well, Alderwoman, is that all you had? Okay. Please proceed, Alderwoman.
Have you spoken to SLMPD to make sure that nothing that we're going to do today is going to inhibit or interfere with their ability to enforce the law?
No, removing loitering, though, I don't think would prohibit it. Again, they have other tools in their toolbox that they use that, when you look at their stats, are not using loitering. And again, referencing to that state law, just thinking about the potential avalanche that may be coming down if our law enforcement are using that, and then somebody want to go out and try to cite that case against our own police department. So again, I think they would use trespassing or other means before loitering, especially potential litigation, since it has been ruled by the Supreme Court.
Thank you.
Alderman, you're recognized on the close.
I really do appreciate all my colleagues' input, some before the committee hearing and also during committee hearing. Again, the goal and spirit of the legislation is one, to tackle a lot of different ordinances that are already on the books that just need to come off due to state statute. Some of it's for as the insane and mental health individuals. I think that's we all understand that, and not saying that people should be charged for bringing people who have mental health illness into the city, or putting them back in the custody of law enforcement after they go to the hospital. I think the chairman spoke very good about kind of the drunken part, how that would just lead to discretion of people being in jail for a long time. And what we've seen again through drug court is rehabilitation. I do get the concerns of, like I say, my colleagues with the loitering. In my opinion, just looking at the data, it's nothing that currently still stick. And I think, even like the chair said, I think trespassing would tend to be a stronger penalty on an individual if they happen to be loitering, or if somebody assumed that they was loitering. And hear the concerns of that section with the prostitution, far as the neighborhood protection. I think that's an easy cleanup fix, as well as looking at the other things striked out. But like I said, we'd be willing to work with my colleagues through the process, as I've done with you all on other pieces of legislation, and shown a track record of making those changes before actually taking the final vote. So I would ask the committee for a do pass recommendation.
Is there a motion?
So I move that we pass Board Bill 110 with a due pass recommendation.
Second.
All right, it's been moved by Alderwoman Saunier, seconded by Alderwoman Clark Hubbard, that we pass Board Bill number 110 out with a due pass
Committee sub.
recommendation.
Committee sub.
Is that the committee sub?
Excuse me. 110 committee sub out with a due pass recommendation.
Okay, so I'm sorry. So did Sanye make the move to pass Board Bill number 110 committee substitute?
Yes, I make a motion that we pass Board Bill 110 committee substitute with a due pass recommendation.
And then Alderwoman Clark Hubbard, are you going to second that motion? Okay. So then, yes, it's been moved by Alderwoman Saunier, seconded by Alderwoman Clark Hubbard, that we pass Board Bill number 110 committee substitute out with a due pass recommendation. Madam Clerk, will you please call the roll?
Alderman Oldenburg.
No.
Alderwoman Clark Hubbard. Alderwoman Keys.
No.
Alderwoman Velazquez.
Aye.
Alderwoman Sanye.
Aye.
Alderman Aldrich.
Aye.
Chair Narayan.
Aye.
We have 5 aye votes and 2 no votes.
With that, you've sustained the motion and passed Board Bill 110 committee substitute out with a due pass recommendation.
Thank you all.
With that, we will move to our last agenda item, which is the Prop S discussion. I know it seems like we were just discussing this quite recently, but we are trying to change that cycle, as we had discussed during the previous iteration of this. And so that means that we need to get on the ball a little bit quicker this time around. So one of the things that Mr. Pinckney had brought forward was the timeline on how he would like us to proceed. I wanted to share that with everyone because we do have some things coming up relatively soon. So if anyone has any questions or concerns relating to either the timeline or any of the issues brought up in the timeline, we can address that. And Mr. Pinckney couldn't stay for the duration of this meeting, but he did ask that anyone who has any questions or concerns reach out to him. So the timeline will be December 1st By December 1st, we need to approve Prop S and the third-party review RFP language if we want to keep that third-party review. December 1.
Is a Sunday? Is that right?
And then by December 15th, we would want to open the third-party review RFP. By January 15th, we'd want to close the third-party review RFP. We'd want to open the Prop S RFP February 1st. The Office of Violence Prevention would hold a meeting in February to go over the RFP. We would close the RFP by April 1st. The third-party review would be completed by May 1st. The Office of Violence Prevention would then provide the Prop S report at the first Public Safety Committee meeting after May 1st. And we would provide organization names and funding by June 15th, which would get the funding out prior to the summer break. So does anyone have any questions, concerns, issues there?
I do.
Please proceed.
Thank you. I just, for clarification, and actually Alderwoman Keys and I both made note that December 1st is a Sunday, so.
The 15th. The 15th is Sunday as well.
Yeah, and the 15th is as well. So you said December 1st, but I'm assuming that you really mean it would be November 28th, since that's the Thursday?
Yeah, we just need to have it done before, what he's saying, before the 1st. So these aren't like by end of business on this day.
Okay.
This is just a book, it's to say, have everything done before this date, yeah.
Okay.
And can you also, you're going to email out that timeline to the committee?
I certainly can.
Thank you so much. That would help, so I know what we're going to be held to.
Mm-hmm.
And go ahead.
Thank you, Mr. Chair. Can y'all hear me? Okay. I know, don't tap, all right. Is it working? Okay, maybe it's just low. Just a thought to remember as we move through this process, especially like in, I don't know when the board goes down. I think we may go down like in February. We have an earlier break because I know some folks will be running.
Since it is an election year, there is complications there. And so we did move through this with the Board of Aldermen schedule in mind.
Okay. And then just, I guess to remember, I mean, because then maybe you'll still be chairman. Hopefully you're still chairman. But, it could be a different chairman and different committee. Sure. When some of that information is, I think, like they come and provide information before board may change. And I don't know if we'll have to provide that to new board members or new to committee members, but yeah.
So, yeah, typically, at least what I have done and what I've seen done in the past is when there is changes to the makeup of the Public Safety Committee, however, whatever those changes may be, there's at least kind of an informal, like, here's where you're at in the process, so that people have the opportunity to get up and running, even if they haven't been there from the beginning, because in election years especially, oftentimes you will find people on the committee who were not here, or there will be people who were on the committee who are no longer on the committee because they changed committees. So I anticipate that the makeup of the committee may change to some extent, and so we'll just have to make sure that we get people up and moving on this timeline. But yeah, I think the biggest thing to think about right now, the biggest takeaway from this is to please just take a look at that third-party review RFP that we used previously, and if you have any changes that you would like to be made to it, please bring them to Mr. Pinkney as soon as possible to make sure that we can work through any issues in committee, and that he can have, basically completed RFP language for this committee to pass out in a timely fashion so that we don't get behind the 8 ball. Go ahead.
Thank you. I know that we have our timeline, but I did want to lift up some of the schools talk to me about some of their frustrations with our timeline, because thinking about some of them who have summer programming to do.
That's the reason for this change.
I know, that's why I just wanted to share, like, I wanted to uplift for some of my colleagues for transparency purposes.
Oh, I got you. I got you.
Yeah, that's why we're trying to, yes, okay. That's why we're changing the timeline, because I know, like, Roosevelt High School and several schools who are interested in getting the funding have certainly reached out to me with some of their frustrations in the past, and I think they will appreciate our timeline that will allow for them to do their academic and summer planning at once and know what they're getting.
Absolutely, yeah. The reason for the change in the timeline is to try and make summer programming more accessible. I think that, you know, we're all aware that summer months are oftentimes when we see spikes in violence, and this funding is to try and alleviate some of that. And so to try and maximize our bang for our buck here, we want to make sure that we are funding programs in a way that they can actually carry through all summer long. Awesome. Does anyone else have anything further, or else I'll entertain no, we don't have any excused members. Do we have any written testimony?
We have none.
Okay. Does anyone have any announcements? Oh, I guess I should. Yes. Yes. For the several people at home listening, please make sure that you're driving safe and sober this evening. Starting in just a couple hours here, there's going to be little kids wearing masks. May not be able to see well. It's going to be dark. They're going to be all jacked up on candy, doing God knows what. Maybe not looking both directions before they cross the street, and generally doing insane kid stuff. So please make sure to look out for them so that we can all have a Halloween.
And to the kids at home, I am an adult that's jacked up on candy too, and there's many adults that are jacked up on candy. So, but also, I'll probably say this again on the floor for tomorrow. Please, to the colleagues that are here, make sure you check out the art exhibit that is in the Kennedy Room, also in the artists of the 14th. But also, I wanted to, and I forgot to say it earlier, thank my legislative assistant Matt also for the help on the piece of legislation earlier. So that's all I got.
Okay, Alderwoman?
I just have a quick announcement too, in line with the Halloween festivities. This evening, we are looking for a safe alternative that is sponsored and taken on by the city yearly. I love this haunted hall here at Woe Rec Community Center, 1515 North Kings Highway. This year, they're not only having the haunted hall experience, but they're also having a bonfire with s'mores making, trunk or treating. It's always a great event, and to see the children again in this safe space enjoying the holiday, it always gives me hope over at Woe Community Center. So again, 1515 North Kings Highway from 5 to 8 tonight. It's Horror Night with City Rec.
All right, and then Alderwoman Sonia, you had something?
Yeah, I know we were talking about kind of delinquency. I'm going to be participating in the delinquency of Halloween for sure. So I just want to let any kids and constituents know in the 7th Ward that I do believe in taking candy. I'm not one of those adults who the candy is just for the kids, all not some. I want my candy as well. I know sometimes when you go to people's door, they like, oh, where's the child? The children are all within us. So I wanted to just lift that up. And also, I know we probably have a lot of events in our community, but I'm really looking forward to the Cherokee, Benton Park West, and Tower Grove East Halloween events tonight as well.
I got one.
And I wanted to thank also Ms. Murda for her work on helping me to read through Alderman Aldridge's long, extensive bill and going and finding all the relevant codes and things like that. Thank you so much, Ms. Murda.
All right.
All
Alderwoman
right,
Keys.
well, since everybody's gonna make an announcement,
Hold on for 1
Okay.
second, Alderwoman. Alderwoman Keys has the. Has
Yeah,
the
just
floor.
let me get this in real quick. So, at Rock Church in the gym, starting at 5:30, we will be handing out candy. Let the children know that Alderwoman Keys is on the way, bringing the bag. Thank you.
All right. Alderwoman Vasquez.
I'll be joining some folks in
that's
Shaw, handing out cotton candy and snow cones if you're in the, on Spring in Shaw, so, look for me, so I'll have some cotton candy too, so.
Great. Well, with that, I will entertain a motion to adjourn.
So moved. Second,
All in
no
favor?
objections.
All in favor signify by saying aye.
Aye.
We
Aye.
stand adjourned.